actually in the civil procedure code, there's no separate procedure. There's just a summons that goes initially, which says that this is notice stroke summons. You are required to appear. If you don't appear, either directly or through counsel, an arrest warrant may be issued to procure your presence and to secure documents and so on, so you are advised to come. So once and for all, your notice stroke summons is a comprehensive summons to the person. Now he doesn't appear. The civil procedure code allows you now to straight away in your discretion issue a non-bailable warrant. You can do it straight away. You may, if you want, issue a second notice and say that this is to inform you that you have not appeared. So now we are giving you notice that you will be arrested if you don't appear on the next year. Warrant will be issued if you don't appear. So the procedure actually is very clear. And it's not necessary for you to wait 3, 4, 5, 6 times, then try and get him again, then try and give him a notice again and so on. If the initial notice is very clear that if you don't appear, you can be, a warrant of arrest may be issued, then go ahead and that will quicken.
Here, you may take this notice itself as a summons, because here very clearly we write it.
Or the commissioner who is hearing the matter.
No, it is registered. It is sign will go name of the registrar.
Okay.
But under the SD of this concerned commissioners.
What would be the option for commissions that do not have registrars but only secretaries?
Please pardon?
If the commission does not have a registrar and there is only a secretary who is a bureaucrat, then who will sign the
He is designated. Can I clarify?
Because there is no power for delegation of authority in the RTA. That's the problem.
No, Venkatesh, look, this power is only with the commission. It is not with the registrar, it's not with the secretary. So if anybody else signs, it has to be a delegated. Now the power is not delegated. See, you have a format in the government, I don't know if you use it, saying I'm directed to. So the signature can be even the peon, it doesn't matter. But it is in the name of the commission
Name of the
that thing
commission
goes out.
Order has to be information commissioner. It can be issued by registrar or joint registrar.
But can I, now that, see, I'm not quite sure why we are so involved with this whole issue of summons. Because as Shailesh said, and I totally agree, under the RTI Act, there is no necessity to have anybody present. So as long as you decide, you give an opportunity to somebody present. If they don't come, great, yeah, you give your order. Now, why do you need to summon people? Why do you need to issue arrest warrants? I'm not quite clear about it.
Yes, the summons is for two things. One is for the person to come.
But why do you want him to come? You don't want to come.
I tell you one thing.
And the second is for documents to be produced.
I tell you, if PIO does not come himself, none of the commission's order will be complied. I tell you, and it will be just like our order will be lying in there. So again, what is called expense of non-natural petition. We have done that earlier. We just pass our orders, but they don't comply.
Yeah, but it is doubtful whether the commission can issue summons to the PIO in circumstances when he is represented by an advocate. The Orissa order may be quite right in the sense that
I have said that advocate they come. He also allow them to come, but because of he himself we didn't do that. There are rare cases where no advocate, nobody has represented, even the junior officer has been represented. These are the cases. There are no such cases where they have represented. So someone comes there on behalf of, then matter is clear. Then we ask them, okay, this is the thing that you have to clarify. Or if you cannot answer, you cannot furnish the information, let the concerned person comes. Simple. But when totally someone does not come, no representation at all for 5 times, 6 times, what can be done then?
No. If nobody is there, you obviously have a right to summon. If he is represented by a lawyer, then it is doubtful whether you can summon him personally. It's possibly open to you to do that. And thirdly, your powers of summoning are very wide because it is
in using the powers of summons for that, because you inform somebody and then appeal on his point, with notwithstanding that nobody will act on it. To my mind, that shouldn't be the case. Then there is a place where in the process of your inquiry, you need to get evidence from somebody, either documentary evidence or oral evidence. In which case, if that person does not come, you have no other option but to use a summons. There is a third thing which has been mentioned, that you want to use the power of summons, and in fact Arvind is not here, otherwise he would have mentioned it again and again, to ensure compliance. Now that's an extra legal use. You see, that is the use by which you say, okay Cham, I'll harass you till you comply with my order. To my mind, that is not the sort of thing which should get universally used, because it will have a reaction to it. I mean, if you start summoning officers just to show them that, okay, if you don't do that thing, you do it once, you do it twice, but after that there will be a reaction to it. So I think, because there's so much excitement about this power, I just want to put in a note of caution that it is only in 1 or 2 or 5% of the cases where you actually want oral evidence or documentary evidence. If I'm not mistaken, this is my understanding. Yeah, and it is only here that you need to use this power. Not in the first case, to my mind, it's a waste of time. Just issue your order and get on with it, especially if you have backlogs, etc. And not in the third, unless you feel it's an exceptional case where you need to make an example of something. This is my word of caution.
No, but based on commission within 10 days of passing this order, I have never got this information. Now if I go to the commission again it's like again in the last in the queue. So what do I do then? I mean, the case came after 6 months or maybe 8 months or 10 months, and then after again the order was passed to provide the information, but there is no compliance. Then I go again to the commission, then again I get next year, after 6 months or 7 months. This happened 3 cases, 1 department.
What we are doing is that we don't close the case unless the information.
That's what I'm talking about.
That is what we are doing.
That's continuing my understanding. You see, we are not discussing that.
These principles of natural justice and opportunity to be heard has to be given. So you can't just close the case with a penalty order.
No, I didn't suggest that. I said that you give the person an opportunity.
Right. No,
But if that person doesn't come, there is no need to issue a summons.
because my experience is, because of the commission's desire to, or a presence of the first appellate authority, slowly I am getting a trend now where senior officers are delegating this responsibility to junior officers. Because, invariably, we are the commission, we require their presence and they come, they spend it, and they are very senior officers most of the time. So slowly I see from the director level, the first appellate is getting into the deputy director and below and below. If that happens, the whole credibility of the first appellate also will get a big jolt.
If you don't mind, if we can go back to the point of the continuing mandamus.
Okay.
Is there any other interventions on that? Finishing the case once and for all, as opposed to keeping the case until, this is what Justice Shah mentioned in the morning speech as well, the continuing mandamus and so on. Yeah,
I just want to, in fact, Shailesh, you mentioned that, when one closes the case, we have seen that when one goes back there is really no way that people don't really know how to actually go back to a case which has been closed. So, and then to go back and then to the queue becomes a problem. So how does it?
I really believe this is not very difficult. And I would submit again that most RTI activists in this country are forgetting one fundamental thing, this whole issue of pendency, which is today very low focus. I do believe we must all demand that all commissions must dispose of matters in less than 90 days. According to me, that's a non-negotiable. By and large, there will be some exceptions sometimes, but by and large, cases must be finished in 90 days. In my commission, in my office, what happens is, whenever a complaint comes for non-compliance, there may be defects. Like, okay, I discovered after a public hearing that there were defects in our handling of non-compliances because it was being done very generally. So we've now corrected that. But what is now happening is, if you get a complaint of non-compliance, within about a week, somebody looks at it and sees whether it's a genuine non-compliance or not. My own gut feel is non-compliance is of an order of 15-20% of the overall orders where we order that information must be provided. Some of these are actually not non-compliances. They want something else to happen because that doesn't. Some of them, I'm saying this is both ways. But the majority, which is 70-75%, are getting their orders in less than 90 days. And hopefully getting, because they are not complaining to us that order is not being complied with. When you go into this route of saying, no, we'll keep calling for a hearing, then your outputs will drop dramatically. And I'm again submitting that wherever you are talking about this continuing mandamus, what's the total output like? Please take a look. The kind of costs that we talk of per decision are then ridiculous. I'm sorry, but civil society is not even talking about what it costs for a decision. But saying, no, please do this, please do that, please do that. Wherever there is large activity in the bigger states and the center, I do not think anybody will achieve continuing mandamus without dropping the output. And if we do that, it means, forget 90 days, people will come after 1 year and 2 years, then you say, okay, because I came after 2 years, then you will continue my mandamus, and maybe in the next 3 months, even if I've got a non-compliance, you will manage to finish my case off. I'm saying, compared to that, the pressure on PIOs and the system, when you can ensure disposal in less than 90 days, is far higher. It's a matter of an overall strategy. And this, you can find out, you ask PIOs, when they feel that, oh, if I have not given, in about 3 months or 4 months, I'm going to have to do this and face this and maybe face a show cause. The overall pressure on PIOs is far, far superior than saying, you wait for 2 years, and when you come before the commission, you'll be completely satisfied. I mean, it's a choice between these two.
Can I ask a question? Where is the power to reopen or to look at the enforcement of a case that is closed?
I have the answer to this. In a recent case, G. Basavaraju versus Arundhati and others, contempt of case, civil contempt case 525 of 2000.
There is no civil contempt.
Karnataka High Court has given that the provisions, the penalty provisions contained in the section 20 of the right to information can also be used by the Information Commission to get its orders completed.
No, that's clear. No. You can have an order made, you can do a penalty, no doubt. You can keep it pending, you can pass subsequent order, no. But once a case is closed, case disposed of, where does the power lie to reopen the case because...
There's a section 20. Section 20 has got the...
No, there's no power to reopen.
Karnataka High Court has given a decision, it is already...
We'll see. See, why I'm saying this is, I just look very cursorily, I'm not so much of an expert, but it might be that subsequent orders may become vulnerable. As you know, like for example, it's very common in labor courts, they say you become functus officio. The moment you sign, when somebody says, no, so there's a mistake, you say, nothing doing, you're end, matter ends. So, where does the power come to reopen?
That's what Justice Shah said this morning also. If I understood him correctly, the point he made